In the area of civil litigation, Rob is personally handled as both plaintiff's counsel and defense counsel a wide variety of matters, and really has a wonderfully, incredibly varied client base with past and present clients including commercial airline, professional athletes, restaurants, health and fitness clubs, all of those things too, a national fire and water restoration company, and churches. Rob has appeared on the Today Show, Good Morning America, and MSNBC. So for those of you who were present yesterday and heard Frank Clem talking about working with the media, I wanted you to know that Rob is someone who also has a great deal of expertise there. So Rob, thank you for being here, and I'll turn it over to you.
Kristen, thank you. Very nice introduction. When Aaron asked me to consider me to speak here today, I thought about, well, what's important in the practice of law, and the idea behind a solo network of practitioners and an institute. I thought it was a great idea for Stetson. And of course, to do that, y'all got to make money, and y'all got to collect that money. So today's hour that I have is really boiled down to one thing: money. Making more money by having billing procedures that you implement consistently, and having a collections procedure that you have implemented that is also consistent and flexible when you need to be. In the words of the late, great Steve Jobs, my favorite things in life don't cost any money. It's really clear that the most precious resource we have is time. But as lawyers, all we have is time. And for us, time is money. As I've said before, money's not the most important thing in the world. It ranks up next to oxygen, but it's not the most important thing in the world. Now, let me introduce to my right, Erin Williams. She's my firm administrator, and what I'm going to ask her to do, does everybody have a business card? Does anybody not have a business card? Okay, we're going to do real quick is if you can take a business card out. I get a little honorarium for being here today, which is kind of funny, Stetson paying me when I've given Stetson all my money. But to that extent, they're giving me a little bit of honorarium. And what I've done is, because I applaud you for being here today, I'm going to give you something back. But I need your business card to do that, so you got to stick around to the end of my presentation, so I force you to your seat. And we're going to have a drawing at the end, and I'm going to give back to you all for being here. So if you can pass your cards maybe to your left, to the person on the left. And if you don't have a card, Aaron will give you something to fill out. So you're going to put it in a bag, and at the end we're going to have a drawing. You want to do that, Aaron? I called Aaron Swift yesterday. While you're doing that, I'm just going to talk to you for a second. I called Aaron Swift yesterday, who's done a fantastic job, I think, in putting this institute program together. And I asked him, I always like to know the demographics of the people I'm going to speak to. And you might be interested to know that most attendees here are 35 and younger. 85 to 90% are true solo practitioners. And we have graduates all the way from the class of 1964 to December 2011. So we have quite a range of people, quite a range of experience. If I could see a show of hands, how many people have been practicing less than 5 years? Maybe more than half. How about 6 to 10? And more than 10. Okay? All right. Well, my fundamental purpose today is not just billing more time, but billing time more accurately. When I was preparing for this, I asked myself, what would I want to know sitting in your seats today? Number one. Number two, when I was a solo, which I'm not quite a solo anymore, but when I was a solo, what one thing would I like to have known that I wish I know that I know now? So I hope to answer those questions. So the first one being, what information would I have wanted in your seat, other than my phone number to call me to figure out when you have a problem? And what would I have liked to have known as a solo when I was a solo? Now I realize each one of you here paid a couple $100s to be here, and I want to give you as much information as I can. And you'll see through some of my slides there'll be a QRS code. If you have a smartphone, you can scan that slide and put my contact information in. And in the hopes you do need, and I know I have a mentor ribbon on. If you do ever have a question about your practice, I have gone to the University of the School of Hard Knocks, and I do understand what it's like to be out there practicing law on your own. So if anybody's interested at the end, I'll give you even my cell phone number. If you have a question, if you need guidance at any time, I'd be happy to do that. So I had to come up with, Aaron Swift told me, hey, come up with 6 to 10 principles. So I've come up with 9 principles for time, billing, and collections. The 10th one you'll see in your materials is really the ethical obligations that are woven throughout these 9 principles. These aren't my secrets, they've just worked for me. And obviously, not every shoe fits every foot, so you're going to have to adapt them to the extent you feel comfortable. And understand, I'm a pretty aggressive, I have a trial practice. I'm both aggressive in my practice and I'm aggressive when it comes to getting paid. You have to balance out how comfortable you feel and how aggressive you want to be on getting paid. The principles I'm laying out, although I don't do any contingency work, it's either flat fee or hourly, I think the principles that I lay out, some of them could be applied to a contingency practice. I've spoken to some other graduates from other law schools, and quite frankly, they said, well, why can't we go to this? I said, well, I guess your law school doesn't really care about you. So I applaud Stetson. Let me go to the first slide here, and you can see this cartoon I thought was kind of funny. He said, in his professional opinion, his bill was not outrageous, and then he billed me for it. I mean, it doesn't get any better than that. You know, the reality is this. Clients don't like paying attorneys. Show me anybody, tell me a client that you've had that said, I love writing that check every month to you. Because they generally have a problem. And lo and behold, you come to realize that if you help them with their problem, say in a criminal case, and they're not convicted, or in a business case, and they're not found liable, or they do establish liability, well then they were right all along. I should have never had this charge brought against me, I should have never had this lawsuit brought against me, so you did what you were supposed to do. I've come to realize that, you know, I don't get a whole lot of back patting anymore for doing the job you're supposed to do. You just do it, and my reward is my own self-gratification and level of professionalism, and of course, you know, some dead presidents in my wallet. So that's our reward. You get paid. The practice of law, I'm not telling anybody anything new here, is very rewarding. It's very challenging. It's why we all do it. There's a thrill about practicing law, at least there is to me as a trial lawyer. But it also can be very frustrating and depressing at times. That's why they have these substance abuse classes for lawyers. There's a burnout factor in our profession. There is time needed to take time off. But it's compounded when you're trying to collect money and get paid and put food on your family's table and pay the electric bill and pay your employees or pay your student loans. That compounds the stress in which lawyers have to practice. And as a solo, it's no different. Just a little background experience from me. I have a bachelor's degree from University of South Florida. Well, can we skip back one? Graduated from Stetson in 1998 with honors, as Kristen said. I was of counsel to a law firm in Palm Harbor called Florin Robig, which my office was right next to Miss Oros, who's attending today. Then I went out and purchased my own building and grew my firm to where it is today. When I started practicing in 1998, my starting salary, now this is after leaving Stetson, of course, and I made a whopping $25,000 a year as an assistant state attorney. Today, just for purposes of giving some credibility behind knowing what I'm talking about, right now I still consider myself a boutique firm. There's 4 lawyers in my firm, 7 support staff, so we have 11 people in my firm. The gross revenue is over $1 million. So it's not been that long, but done right. I think with the principles that I'm going to give you, and you apply them, it's possible. Let me go to first principle. Key number 1: be proactive instead of reactive. As the old saying goes, an ounce of prevention is worth a pound of cure. It's much easier and better for you to have insurance before you get sick. Every lawyer in here understands this concept, but when it comes to application, I think that's where some fall short. Screening potential clients. I have a form here, well, it's actually multiple forms that we use in our office, and you're going to see riddled throughout my presentation today. There's hyperlinks to some of my materials. I'm not suggesting that you have to use them. I'm just showing you what I do in my practice, and in the event you want to not recreate the wheel, feel free to retype it, copy it, do whatever you need to do to make it adapt to your practice. But these are things called PNC sheets. PNC stands for potential new client. I think every firm that has a potential new client, call them. This is the first thing that should be filled out. And on the sheet, and I have a stack of them because they're not in your materials, if you want to take one after the presentation. But in here is a list of information that you want to know from the client. We have different colors, not because I like rainbows so much, but because it identifies the particular matter. Pink is crime, green is business, salmon color is a bankruptcy, and yellow is a foreclosure. And each one contains questions, initial questions that we want to know in my firm even before we set an interview with a person. And we get some background information on the person, such as in a criminal case, we get all their vital statistics, their name, their date of birth, their phone number, their email, do they have any prior records, the type of the crime it is, where did they get my information from, was it a referral from another lawyer, was it a newspaper, was it a direct mail piece, it helps us track expenses, has the attorney's initials at the bottom, who did the intake. We do this for every potential new client that calls. This is our first contact intake, and then this is generally done by an assistant or a paralegal, but I've done them, and then it would go to an attorney to evaluate. And we might pull some public records or public documents in reference to this very first sheet, such as the criminal sheet. We might go to the Pinellas County or the Sheriff's Office sites or what's called the Consolidated Justice Information System in Pinellas County. And we might pull their information and staple it to the sheet so that when we do finally talk to the client, which we always talk to clients that day, unless there's a significant issue, but we can't, we have all of our information right here. So this is the first step in terms of getting contact with the client. Screening is vitally important. This is not a practice management seminar, but I can tell you, I've come to learn it's as important to know when not to take a client as it is, maybe more so, than when to accept a client. And I understand sometimes, a good friend of mine who's a judge in Pinellas County says to me, when I left the state attorney's office, I was doing wills and trusts and estates. He goes, I hope no one ever dies, because I don't know what I was doing. The reality is, as a solo practitioner, you know, right, you gotta eat, and you gotta pay those bills. So I understand you gotta sometimes do things and take the next step and acquire a little bit of knowledge on that practice area. But screening a new client is vitally important. The screening information is going to come, when I say screen, I mean find out as much as you can about the client, because this is going to help you later on if in the event you have to pursue the client, okay? Not something I encourage, but it does happen, just like any other creditor when you want to get paid. And it may be something you decide not to do, but we'll get into that. The other key document, which we're going to get into, is the retainer agreement. But the idea here is being proactive and not waiting for a catastrophe to occur or waiting for your accounts receivable to be so high and the client disappears, or they're not willing to pay you, or they switch lawyers. You want to get paid. My goal here is for you to understand you're entitled to get paid. And it's probably axiomatic to hear that, but it's true. There's a service by LexisNexis called Smart Links. We subscribe to it. I'm not suggesting you have to do it. I'm just throwing it out there. It's a service that allows you to really get as much background information on anyone that's out there. If you pulled my Smart Links, you might have 30 pages of information on me. In fact, when I was just recently applying to another bar, I think the New York bar or something, and it asked me all my addresses. I had forgotten about some of the addresses I lived at, but Smart Links has your addresses. You can find voter registration. You can find how many vehicles people have. You can find about judgments that people have. You can find out about prior convictions people have. It's an all-in-one database, so it's a very useful tool for us. Also helpful for me, and you can get this service, you can charge clients a cost for this. And this is something similar to an asset background check. You could probably charge, well, we charge $199 for it. Client comes in, let's say Ms. McCartney comes in and says, hey, I want to sue this person. We say, great. There's a couple factors we might want to be aware of. Are you going to collect anything at the end of the day if you're successful? Let's run a Smart Links check to see if they have anything. Do they have real estate? Do they have cars? Do they have boats? Do they have judgments? Are you a creditor that's the fourth or fifth in line? These are things that you might want to consider, or the client might want to consider before they actually initiate litigation. So Smart Links will give you that information. It's vitally important you get a copy of, for purposes of today's world of business, you get a copy of the driver's license of the person you're dealing with. I can't tell you how many practitioners don't do this. You have to get a copy of their driver's license. There's rampant identity theft. If a client is going to write you a check, you make sure that that client's driver's license number is on that check. All right, it's got to be on the check. If there's an issue with non-sufficient funds, then you've got the ID of the person on that check. Now, if it's $200, you know, maybe you let it go. But if it's a significant amount of money, if you haven't checked to see if that check clears before you start work, and you get into it and the bank, it comes back, you want to have your driver's license on it. This is a copy of our civil retainer, which is in your packet. And those that are currently practicing, will you raise your hands if you're currently in solo practice out there doing it? And keep your hands up for a second. Now put your hand down if you don't use a retainer. Okay, so everybody uses a retainer. Thank you. I've tried to structure my retainer in such a fashion as to preclude problems later on. As lawyers, you know, sometimes in business deals, they'll say, hey, the lawyer is going to be a deal breaker. Okay? No, we're going to be deal makers to make sure we don't have any problems. So we try to draft a around problems with the foreseeability that we could have a problem. So my retainer has attempted to do that. If we go through my retainer agreement, you'll see, can you scroll down here? You'll see initially we have a scope of engagement, which identifies the exact matter in which we are going to represent the client on. The next paragraph goes to, because of proliferation of business entities, this paragraph really says what we're not going to be representing you on. And that's vitally important also. I've got a case right now with a Canadian plaintiff and an American defendant and his company, and it's a civil case, and he's also been indicted in Illinois. Well, don't come ask me why aren't you showing up at my sentencing in Chicago. I thought you were my lawyer. Well, my retainer specifically identifies the scope of my representation. Not that that scope can't be expanded, but you want to make sure the client and everyone understands what you're not going to be representing them on. The next conflicts, it seems pretty obvious, but when you have this issue come up, it's not a pleasant one. I represented a lawyer, a law firm, and multiple parties in some civil actions, and just recently, I've got a waiver because there was potential conflicts involved, and just recently the lawyer has been indicted, and I feared he was going to try to have me removed from representing my other clients. I got no written waiver, plus this language up front, controls, and I called the bar, and it says you're good. Okay, so having a conflict provision in your retainer agreement, I think, is also important. Keep going. It obviously identifies what your fees are, in particular, if you can. Keep going. And go back down. Refundable versus non-refundable retainers. It identifies if you're going to be paid a refundable retainer or non-refundable retainer and how that will be applied. To 5A, go to 5A. Here we go. My retainer, because I've had this issue come up, allows for my firm to access a client's credit report. If they don't want us to do it, they'll cross that out. But you can't do it unless you have consent. So if you're going to include that in your retainer agreement, if you think you're going to be pulling your client's credit at some point, and that might be a very realistic possibility when you go weigh the risk of whether you're going to continue representing this client because of possible accounts receivable owed to you, you want to know where does this client stand from a credit risk standpoint, so that you can access their credit report. Electronic records, it's just our policy on what we do with electronic records. Florida just implemented an e-discovery rules that have been in place in the federal courts. We have a policy on that, cooperation, termination of clients. Keep going. Arbitration becoming pretty prevalent. Two things about arbitration, and you'll see later on, I'll discuss them, but in terms of a retainer agreement, an arbitrator, has anybody ever arbitrated a case? Okay, Mr. Hagan. Generally speaking, when a case goes to arbitration, the arbitrator can't award attorney's fees. Okay, that's got to go back. Once you get an arbitral award, you confirm it with the circuit court, and then you have a motion for fees with the circuit court judge. However, unless the clients consented to the arbitrator awarding fees and the reasonableness of those fees. So we include that in our retainer. It makes it much more effective since we're going to be, we've arbitrated under the American Arbitration Association, and there is fees, which we'll learn about here today. We'd rather have the arbitrator deal with that issue up front and then confirm the award, the entire award, with the circuit judge. Okay. Next one. Social media. We had to address social media in our retainer agreement because some lawyers have been just recently grieved throughout the country for even making a reference to a client's case in any social media advertising. You've got to get consent, and the client's got to understand he's given you, or she, or the business is giving you consent. Even if you reference or talk about a case, and the client files a grievance, you're going to have a problem. So we've addressed social media in our retainer. Yes, ma'am. Hey, Robin.
Does that apply, let's say you have a website where you're listing some of your recent cases and, results for those cases, and identify those cases, you have to get consent from the client for that as well?
I think the better practice, given the recent line of cases that have come out from the Florida bar and other bars around the country, I think it's the writing on the wall. I've got cases from like on avo.com on there identifying our cases, which we didn't have 10 years ago. We just took those cases and pulled them out of our web. We didn't get consent. I haven't been grieved, thankfully, but I think it's a better practice. Again, another preventative measure to let the client consent or not consent. If they cross it out, they cross it out, but at least we can have something to later identify that the client didn't object to it and we're going to possibly use it. Billing policies. I know a lot of firms don't use billing policies. Again, in a fee dispute with a client, you potentially set yourself up for problems. Let's face it, there's an inherent conflict already existing when you're seeking fees from a client or for a client, or you're billing a client. It's you or them. So there's this inherent conflict that exists already. You want to make sure your billing policies are clearly outlined, your billing structure and procedure, and this is going to set the framework for your guidelines when it comes to getting paid and collections. Okay. Go ahead. All right. This right here is the final sheet. This lists the applicable rates for each attorney, for each paralegal, and for each legal assistant. Again, we don't want any surprises later on where the client says, well, I didn't know that I was going to get billed for so-and-so, or I didn't know I was going to get billed differently for, a paralegal. It's all identified. It's full disclosure. I think you err on the side of caution. Go to the criminal retainer. Is anybody do crime in here? Okay, a handful of crime. Criminal retainer, very similar. Again, depending upon how aggressive you want to be, we have a provision in our criminal retainer that allows for the firm to garnish your wages in the event you don't pay us. Client can cross it out if they want to, but you have to have the language in there. It's got to be 14 font. And again, if you're talking about a case where it's a simple possession of marijuana and you may be charging $1,500, they pay you $750 and they bail on you, it's probably not worth it. But if it's a sizable case and you've done a lot of work and they still owe you $25,000 and you're going to go seek enforcement of your creditor rights, if you don't have some of the other protections that we're going to talk about built in, that might be your last remedy. In fact, it might be the Achilles tendon. If they think you're going to come get it, they may be more apt to work out a payment plan for you. Okay, but you have to have this language in there. Go ahead, Aaron, go down. You can see right there. Under the garnishment statute, wages are exempt from garnishment. About 3 weeks ago, I garnished a American airline pilot's wages. He makes $180,000 a year. He owes my client about $50,000. He won't pay her, so I garnished his wages. American Airlines seized it. Of course, I kind of thought he'd move to dissolve the garnishment writ. He did, and wages are, if you if you provide one half the support of a minor child or another dependent in the family, your wage is going to be exempt from garnishment. However, obviously, if you have an agreement with a client that he's agreed to, or she's agreed to get their wage garnished, if they don't pay you, remember now, this is only if they don't live up to their bargain. That's something you can pursue, and they don't get to claim that exemption. Okay. Quarter reasonable retainer. What does that mean? Could say quarter reasonable fee. It provides security against future billing. Considerations, and you look to Rule 4-1.5, everybody's had professional responsibility in here, but the three types of retainers for the most part are flat fee, hourly, and contingency. You have a couple other smattering of different types of retainers. Might involve a success fee or a common fund fee that you see in class action cases. But what is a reasonable fee? What might be reasonable for me to someone else might say, no, that's not a reasonable fee that I charge. I was talking to Aaron before we got in here. A client came in the other day, young man, simple possession of marijuana. I quoted $3,200. Some people might say, I know people do that for $500. That might be the case. But I have a federal practice up the East Coast. This family wanted to hire me. The case is in Osceola County. My firm is in Pinellas. $3,200 was a reasonable fee to me. You have to decide what a reasonable fee is, and of course, looking at the factors outlined in 4.15 will dictate what a reasonable fee is. What is the scope of your representation? When you're quoting a fee, understand, always be cognizant of what that scope is. I will tell you that I have been retained on cases that I've quoted a fee. For instance, a broker, trader, securities fraud case out of New York. I'm going to New York next month on oral arguments in front of Judge John Gleason. The case started out as a civil case in front of against the Securities Exchange Commission, which later morphed into, well, it didn't morph, but it spurned off a parallel proceeding, which is a separate proceeding by the Department of Justice. So my client then was indicted for securities fraud while the SEC case was going on. My representation fee only included the civil case. So you want to make sure when you quote the fee, you identify that scope. Obviously, there was an additional fee for his new charges, which was the indictment for securities fraud. So you got to consider the scope of your regulations. Many times I represented some car dealerships, Kia, Hyundai franchises out of Jacksonville in civil litigation against Bank of America under what's called a floor plan agreement. Dealers are supposed to get cars in. Once they sell a car, they're supposed to pay the bank back based upon this floor plan financing. If you don't pay, if the dealer doesn't pay within a certain time, it's called outside of plan, and the dealership franchisor can begin proceedings to revoke your franchise rights. That in and of itself is a DOA proceeding, Department of Administrative Hearings, which is generally governed out of Tallahassee. So that would be another, I call, parallel proceeding. But my representation was just with the civil cases against Bank of America. So we're going to expand the scope. We got to talk about more money. Consider travel involved. I have a Medicare kickback case in Kentucky. I joke with my co-counsel because we quoted low six figures on it, and I thought that was a good fee, and there's 6 defendants, and I've come to learn that the other defense attorneys in the case are upwards near $1 million for the representation. They figured they're going to be in Louisville, Kentucky for about a month. They're going to be setting up base camp there. So make sure you quote a reasonable fee involving the potential for the time you're going to commit to it. Collect up front. I don't know why it is, but a lot of people have a hard time asking for money. I enjoy asking for money. Sometimes, you know, you get that client in, and I call it the PIA fee, you know, the pain in the fee that you realize, well, if they pay it, then I guess I'll deal with their whining, you know? So they pay it, and you go, all right, well, that's what it is. Collect up front. Everybody is aware that, you know, my wife is great for this. One of the toilets doesn't work, can't fix it, gotta call the plumber. Plumber says it's $150 to make a trip charge and whatever. I, you know, come out there and put parts in. Plumber comes out, he's there, you know, 3 minutes, and he leaves, and it's like a valve or something for 25 cents. And my wife's like, you weren't even here, you were here for 10 minutes, you know, that whole thing. Well, the toilet works now, okay? And of course, the value of services always diminishes, I don't care what it is, after those services have been performed. Remember now, the client just doesn't generally think they should be involved in the litigation or the transaction to begin with, and so they're willing to pay you right when they come in, but then after it's done, sometimes you're not so fortunate to, when you want to see them, they're not around. So get paid up front. Will your fees include, if you're in litigation, will they include through trial? And that's a big factor. There's a local rule in the Middle District of Florida, local rule 2.03. Can you put it up there? Does anybody practice in federal court besides Robin? Okay, so we got some federal court practitioners. How about criminal federal? One? Okay. Criminal, keep going down. No, next slide. We're on slide 2. There, keep going down. Next page. No? Where's my slide on here? Go back. All right, well, it's not on there. It's in your materials. Local rule, Middle District 2.03. And it does apply to civil cases, but it says, in all criminal cases, non-payment of attorney's fees shall not be sufficient justification for seeking leave to withdraw. We all know the local Florida bar rule that says, hey, it creates a substantial hardship on me. You know, I got to get off the case. Client's not paying me. You know, judges are generally, most judges are inclined to understand, you know, you got a business to run, you got a practice to run, you're not getting paid, they let you off the case. You know, when you tell them to, Mr. Green, the gardener, hasn't showed up, Judge, you know, I'd like to get off. Doesn't work in criminal cases like that in federal court. You get paid up front. So when that mail fraud case comes in and you quote the client $50,000, you better get paid, because you file your notice of appearance and you're in. We had a racketeering case out of Baton Rouge, quoted the client $150,000. We did set up a structured payment plan. We got enough up front to feel comfortable that if he didn't pay us, we'd still represent him. But we realized that likelihood is judge might not let you off the case. So in the Middle District there's a rule, but it also goes on to say, it's like nor shall leave be given to withdraw in any other case, absent compelling ethical considerations. So there's a chance, if you don't get paid, the judge says, hey, Mr. Eckert, you know, you've had this case for 8, 9 months, it's a fast track, it's set for trial, we got a trial date, the client will be prejudiced by your withdrawal. So get as much as you can up front. Principle number 3, I got to be moving along here. Be prepared to defend your claims. This might be one of the 2 most important things I'm going to say today. Keep track of your time, your costs daily. You might be entitled to recover fees from a court, award, or from your client, or you get a grievance by the client in the Florida bar, or you're audited by the Internal Revenue Service. You have to keep track of your time, and the best way to do it is daily. You forget about what you did yesterday. You forget about what you did last week. I have several colleagues that are terrible at this, and some of them have faced problems with the Florida bar. It's not a position you want, an enviable position you want to be in. In addition, if you are seeking an award for fees in a hearing, it gives the judge a better position to award your fees when they are specific. accuracy, billing software. Anybody use billing software? Okay, a couple people. Surprisingly, not that many. That might be the other thing I would have done as a solo practitioner early on. Gotten a good billing software program. Number one, it helps you keep track of your money. Where's your AR? Is it 30 days, 45 days, 90 days? That's what Aaron's great for. Aaron's an accountant by trade. We have stop-loss mechanisms built into the firm when we see accounts receivable and some clients get to a certain point, when we see trust money being depleted. Most lawyers are really bad at math. That's why you're lawyers. However, there's a duty imposed upon you to maintain your trust records correctly, and this helps keep money segregated or identify segregated monies, and it also keeps track of work done. It's inherent that clients are going to complain about how much you're billing them. You need to justify it, not only to them, but again, understand that you might be called out on it by the bar. Understand that your fee records might be the subject of cross-examination when you're seeking attorney's fees. I pride myself on keeping meticulous records, billing records for client matters. I've had some judges say these are the best billing records I've seen. Well, understand, part of that's a function of the software that we use, that we track, but it is recording things. Let me read you this. Professional malpractice insurers concur. A malpractice insurance auditor recently I spoke with said an overwhelming majority of malpractice claims do not involve errors in the law, but instead result from poor business practices such as failing to keep track of deadlines, failing to return phone calls, not providing services promised, or not billing correctly in a timely manner. So billing correctly, billing timely, billing contemporaneously with the transaction that you did is going to save you and possibly make you more money. Here's the balancing test. Understand that your records could fall into the wrong hands. What does that mean? I've had, given my practice on occasions, have had clients, businesses, and homes seized by the federal government, different agencies, Department of Justice, FBI, Federal Trade Commission. More often than not, my records are in their business or their home and seized by the government. Clearly, attorney-client communications on those records. You got to be careful what you put on there to the extent it could be seized and taken into custody. So just be aware of that. Notes on collection calls. First of all, if you're trying to collect money for yourself or your firm, the Fair Debt Collection Practice Act doesn't apply. All right, so you don't have to worry about that. Some of the lawyers are. In fact, I represent a law firm right now who just got retained out of Colorado. Law firm out of Colorado, plaintiff lawyer out of Encino, California, and the suit's here in the Middle District. Law firms getting sued for violations of Fair Debt Collection Practice Acts. We represent them. You can't be liable for collecting your own debts. Now, if you're a debt collection agency, the rules change. Terminating representation, Rule 4-1.6. I've touched briefly upon it, and all these are in your materials. But when you may withdraw, when the client fails to substantially fulfill an obligation to the lawyer regarding the lawyer's services, and the client's been given reasonable opportunity, or it would create an unreasonable financial burden on the lawyer. You know, nobody likes to stand a case that they have to do. Everybody has a friend or a friend's family that calls you up and says, hey, I got this legal problem, you know, can you help me out? I call that involuntary pro bono. I prefer not to do it, involuntary pro bono. I do pro bono. In fact, when I was here at Stetson, you know, I got this William Blues Award, and I just recently been representing this little girl for the last 4 years. They're trying to evict out of her grandmother's house, all that for free. But, you know, the cases that people stop paying you on that, you know, you don't want to report on your Florida bar pro bono form because, you know, you'd rather not do pro bono work, get off the case. Spend time on things you're making money on. So keeping track of costs daily. Aaron, can you go to the next slide? This is an excerpt, you probably can't see it on those monitors. This is an excerpt from our firm billing software. We have gone through different versions. This is a LexisNexis product. It's called PC Law. Maybe some of you are familiar with it. This initial entry by a lawyer in my firm, just as an example, shows the date. You got a timer out there to the left. Timer starts, and you're billing for stuff. The matter is identified, which is an important aspect of the case, because I have some clients, they have 6 different matters with us. They got the DOA hearing. They got the case with the floor plan agreement in Atlanta, Bank of America. They got the case of a floor plan agreement in Jacksonville. So every client has a matter, but if there's multiple matters or proceedings, they may have different matters. My SEC case with the one client, we bill for SEC litigation under one matter number, we bill for the DOJ stuff under another matter. So you need to do that for multiple reasons. One, if you have different amounts of money in trust, if one's a flat fee, one's a billable fee, if in fact you are seeking fees for attorney's fees in a case, it may be unrelated to another case, and the judge is going to be happy to try and have to separate the wheat from the chaff to figure out that this case doesn't relate to this case, even though you billed it under one client. And it's going to make it very difficult for any expert witness to testify. And it makes it very easy for your opposing counsel to challenge a motion for fees when you are doing this, what's called block billing. It's terrible, and I'm not going to name some firms here in Tampa, but firms that have 400 lawyers in it in Tampa that do block billing. I don't know why, although I suspect why, probably because their clients are so big, maybe they don't recognize the problems with it, but it creates a difficulty. How about you draft an entry as a lawyer that says review discovery, 5 hours. I mean, what does that mean? How about 1.3, reviewing interrogatories, 0.4, reviewing requests for admission, whatever. Identify the time that you spend, because again, it justifies your time. Award of fees is more likely. It's easier for an expert witness to testify that's a reasonable fee under a lodestar approach. Lodestar being reasonable time times a reasonable fee. It gives you an upper hand. Block entries are terrible. Aaron, the next one. If you can see it or not, this is exactly what I was talking about in terms of identifying specifically what time and what you spent time on. Okay, go ahead to the next one here. Does anybody in here send out invoices to clients? Okay, maybe a little more than that. Okay, your invoices should restate on your invoice. So you got the time listed, and this is PC Law again. They do everything. It gets printed out for monthly, and then at the bottom they'll say billing inquiries. Call Aaron. Don't call me. Call Aaron. Got Aaron's email. Got her phone number. When's payment due? It's due upon receipt. Unpaid within 30 days may incur an interest rate of 1.5% every 30 days. Well, 1.5, that's 18% per year. Well, that was in my retainer. Pay your bill and you won't get charged it. Methods of payment: Visa, MasterCard, check, electronic debit. Make it easy for the client to get you paid. You can make payments over the phone. So that should all be restated on your bill. So they get it and they go, I don't want to pay a late fee. The other thing you can do is offer an incentive. I haven't found it worked really well, but you can offer a 3% discount in their bill if they pay it within 10 days. People like to save money. I know when I had to hire lawyers before for my trust and estates and all that, and there's an incentive for me to pay early, I'll pay early. Incentive for me to pay cash, I'll pay cash. I'll do whatever I have to do to save a couple bucks. All right. Principle number 5. I gotta wind up here. This is an infamous problem for lawyers. They let accounts receivable, go ahead, next slide, get too big. I don't believe clients inherently are going to steal from you, okay? I don't have that jaded thought yet, but I do believe that when they tell you, I got a client right now who owes us about $100,000, and you'll see what I did with him. He owes me $100,000, he says, Rob, I'm gonna pay you. I'm gonna pay you, I'll never cheat you. I believe him, I do, right now. But if things happen for him in his business, I'm going to be the lowest priority in his life. And it's going to be like, well, you know, I got to do other things besides pay you. I don't think he's intentionally going to not pay me. But let's face it, you don't become a priority in a person's life unless you make yourself a priority in your life. So we use what's called an 80-20 rule in our firm now. What we do is we look at what the total amount a client is paid to date. For instance, if a client's paid $100,000 to date, and their total accounts receivable is $23,000, but they've got $5,000 in trust. We back that 5 out of the $23,000, and they would have essentially owe us $18,000 if we got off the case today. So they're at 18%. So we can still move forward on their case. But Aaron's provided me these alerts, or you're watching, you're getting an alert on your computer or whatever your billing program is to say, hey, we're getting up there towards that number that makes me feel uncomfortable, where if I have to take it in the shorts, I will, but I'm out of here. We use that 80-20 rule. Credit management is important for you as lawyers to understand and implement. It works two ways. You implement the rules for the credit management, and the client follows them. Are they a client that's worth the risk? Is it a bankruptcy case where the client wants you to do some other stuff for them, but yet they're going to be filing a Chapter 7? You got to consider that. It's up to you to be fair and reasonable, but don't set them up for failure. Criminal client comes in, let's say it's a possession of cocaine, let's say it's a $7,500 retainer, and they want to pay, they can pay $2,500 down. My next question is, well, what do you suggest to your next $5,000? How's that going to be paid for you? I prefer not to go more than 30 days and say, well, within 30 days you owe me $5,000. Well, if that's not going to work for them, and I know the case is going to go on longer than that, I'm not going to set them up for failure. So you got to set them up for something they can do, and I think most clients will try to do that. Nobody wants to really alienate their lawyer for many reasons, but you set